Right now, across the United States, there are thousands of immigrants, families, and skilled workers who feel like they are standing at one of the most uncertain points in their immigration journey. Some are deep in the green card backlog, checking the visa bulletin every month and hoping for even a small forward movement in their priority date. Others are preparing their Form I-485 adjustment of status package, carefully reviewing every document, every signature, and every supporting form, because they know that even a minor mistake can lead to rejection and months of delay. And then there are H-1B applicants and employers, watching a system that no longer looks the same as it did just a few years ago, trying to understand how new rules will impact their chances of success. What makes this moment different is your emphasis on wage levels and skill tiers. This means that applicants offered higher wages or positions requiring more advanced skills are more likely to be selected, while entry-level applicants may face significantly lower chances. For many workers, especially recent graduates or those just entering the job market, this introduces a new level of uncertainty. For employers, it changes hiring strategies, salary structuring, and even long-term workforce planning. At the same time, the H-1B modernization rule has introduced stricter standards that go far beyond selection. USCIS has strengthened its authority to examine whether a job truly qualifies as a specialty occupation, whether the labor condition application aligns with the petition, and whether the employer-employee relationship is genuine. Site visits have become more important, and refusal to cooperate can now result in denial or even revocation of an approved petition. These changes signal a broader trend toward increased compliance enforcement, where simply meeting minimum requirements is no longer enough. Employers must now be prepared to provide detailed documentation, maintain transparency, and withstand deeper scrutiny throughout the life cycle of an H-1B petition. Beyond eligibility and compliance, procedural accuracy has become more critical than ever. USCIS has introduced new editions of key forms, including Form I-129 for H-1B petitions and Form I-485 for adjustment of status. These updates come with strict deadlines, after which older versions are no longer accepted. While this may seem like a minor administrative detail, it is actually one of the most common reasons for case rejection. A single outdated form can cause an entire petition to be returned, potentially missing filing windows and delaying cases by months. In an already competitive and time-sensitive system, these technical requirements have become just as important as the underlying eligibility criteria. Financial changes are also shaping the immigration experience. Increased premium processing fees mean that employers must reconsider whether to use expedited services, which have traditionally been a way to gain faster decisions and reduce uncertainty. When premium processing becomes more expensive, some employers may opt out, leading to longer waiting periods for applicants. For workers whose job start dates, travel plans, or status extensions depend on timely approvals, this can create additional stress and unpredictability. For green card applicants filing Form I-485, the changes are equally impactful. USCIS now expects a more complete and accurate submission at the time of filing, including the medical examination form I-693 when required. In the past, applicants often had more flexibility in submitting medical records later in the process. Now, failing to include them up front can result in rejection. This shift places more pressure on applicants to coordinate medical exams, gather documentation, and ensure everything is ready before filing. It also increases the importance of timing, since medical exams have limited validity tied to the pending status of the application. Another critical development is the tightening of identity verification and vetting procedures. USCIS has introduced new measures, including updated photo reuse policies and expanded background checks to enhance security and prevent fraud. While these changes are intended to strengthen the integrity of the system, they also mean that applicants may face additional scrutiny, longer processing times, and more detailed evidence requirements. This reflects a broader shift toward a more controlled and verification-heavy immigration environment. Meanwhile, the underlying challenge of visa availability continues to affect both family-based and employment-based applicants. Even as USCIS updates its procedures, the visa bulletin remains the controlling factor for many cases. Limited visa numbers, per-country caps, and high demand mean that backlogs persist, and progress can be slow or inconsistent. For applicants waiting for interviews or final approvals, external factors such as consular capacity, staffing, and local conditions can further influence timelines. Taken together, these changes paint a clear picture of where the U.S. immigration system is heading. It is becoming more selective, more technical, more expensive, and more heavily regulated. Success in this environment requires not only eligibility, but also precision, preparation, and awareness of evolving rules. For immigrants and their families, this means adapting to a system where details matter more than ever, and where staying informed is essential to avoid costly mistakes.